Hey everyone, it's our last webinar of the year. Can you believe it? It's the end of 2025. Yikes. Thank you for joining us
Thank
today.
you for joining.
Obviously, judging by today's attendance, it's clear we have saved the best for last. We've got a full room today, which is very exciting. And I'm obviously not the only one excited to hear Anthony break down the legal risks we are facing in vet med today because there are many. And I feel like every day I hear something new that I'm like, you wouldn't believe that this is happening. Tony isn't just a lawyer. He's a lawyer with like extra credit. He's got more letters after his name than most of us have on our diplomas. He is a MBA and a CVA, which is that certified value analyst. If that weren't enough, he and his wife, Dr. Jennifer, opened up Riverview Animal Hospital back in 2013. So that is a thriving multi-doctor practice just outside of Cincinnati. He brings, that rare combo of the advisor who can talk strategy and the owner who actually lives it. So I think that that's a great perspective for us. Granite Peak is lucky to call him a friend, and we are even luckier to have him here today. So, Tony, thank you for joining us. I know you've got a lot to cover. The floor is yours.
Happy timing.
Yes, thank you very much. Pleasure being here. And yeah, thanks for having me to Granite Peak and Megan. Thanks for setting all this up. And let's talk about some legal implications of the veterinary practice. This is a talk that I've revamped just for you all today to kind of update to year 2025. In full disclosure, it probably is a presentation that's longer than the hour allotment, but so I may flip through some of the pages if there's little interest in that area, understanding that the slides would be made available to you. And this is being recorded and posted elsewhere. But in short, if you have questions, please ask. And if you want to see the slides, they should be made available to you pretty easily, or you can just reach out to me and get them. All right. So I've kind of went with this idea of legal health, looking at the practice from the perspective of both the way veterinarians look at patients is how we look at veterinary practices. So looking at this idea of legal health, which is using legal best practices to keep your business free from injury. And the way we do that at my law firm is we assess everything on a risk matrix. That's how we advise all of our clients, and that's how this presentation is ultimately going to unfold. A lot of clients call me, and really what they want to hear is, what they're doing is okay, and they want me to green light it. Like, well, that's hardly how business is run. I think you should start thinking of the decisions you're making is to try to make the situation less risky. It's never going to be an elimination of risk. So, some of the topics we're going to talk about, you're going to find yourself in kind of a red category. And the idea that I'm presenting to you today is there's some things that you can do that would start trickling down and making that risk less likely to make it a little more insignificant. When I used to teach business law at university, which I did for a better part of a decade, I kind of made this to show what do business lawyers actually do, and I think I've
Husband,
kind of converted that.
if your
I've
husband
converted that
body,
into the veterinary space. So the idea here is, if your business isn't incorporated, if any of you are working for practices that are, owned by a single doctor, like, step one, fix that. We're not even going to talk about that, but it's just something that needs to be done. Um, but then the contracts, so that's not just your employment agreements, provides a layer of protection. It's your forms and consents and waivers, training manuals, handbooks. Those are all some form of an agreement that are ultimately signed. And then ultimately your policies and procedures. Like those are the cornerstones to protecting a practice. And you should think of those as being cloaked in this idea of insurance, but insurance alone isn't going to protect you. So we're really going to talk about some of these contracts and policies and procedures to reduce risk. Okay, so let's just get into it. I've kind of selected eight of the top legal diseases, we're calling them, or issues that we see that are calling my office the most often. And we're going to go through these, but they are kind of in order here. So employment discrimination, harassment, retaliation. So employment issues are still at the top of the list. It's going to be the most of this presentation. The next big topic that is new within the last couple of years is informed consent declined services. It also happens to be the number one board complaint and malpractice trigger that we're seeing. Dog bites, it's just part of ownership. Misclassifying independent contractors or misclassifying employees as independent contractors. There's a lot of OSHA and workplace safety violations and whistleblowers, hot topic.
I'm
Um,
not sure.
the online defamation and reputation attacks, controlled substances, and one I just dealt with this morning are clients that are causing trouble from a
Mhm.
staff perspective. So if I were to reorganize these into what is the most likely to occur, employee disputes are still at the top of that list. They're up 9.2% just since last year. So that's from 2024. And board complaints, which used to be down here as the kind of the fourth category, has shifted up to number two. So board complaints and malpractice has risen significantly in the last, say, 5 years. And then contract disputes and personal injuries, dog bites, workers' comp, still kind of the top four risk items that are hitting a veterinary practice. All right, so let's just get into it. So, disease number one are employment disputes, and we've summarized them. They ultimately fall into these categories of should have been hired, unfairly disciplined, harassed, discriminated against, retaliated against. You didn't take my disability seriously. I was fired due to some illness or injury. I was defamed, or my non-compete is not fair. So I made a couple notes, just issues that have happened in 2025 from my law office that just fall off this, one chart. I should have been hired. We had a hospital that was dealing with they revoked a offer of employment to someone because they refused to provide a social security number. And the reason that they refuse to provide a social security number is because they believe that they are a sovereign citizen of the United States and they do not play into the social contract, which is the Constitution, and therefore do they not have to abide by the IRS guidelines. That went all the way through litigation, as dumb as that sounds. But that was just one instance that probably cost a client $10,000 only because they properly revoked an offer of employment. I was harassed. Harassment has been expanded into a broader category, which is typically a hostile work environment. And the one we're seeing come up a lot is when you're disciplined or you put an employee on a PIP plan, they see that as singling them out, which is not necessarily discriminatory, except that states are now taking a broad definition of what bullying is and how bullying can become harassment. So we're having to defend a lot of claims where you're just doing a regular improvement plan with an employee and they're claiming harassment. I was discriminated against. We had to defend this one earlier this year for age discrimination. And I don't want to say may have actually been age discrimination, but um, this employer was frustrated with an elderly receptionist because she could not use the computer as fast as everyone else. Turns out that if you're over 40 and you can't use a computer very well, you are a protected class and you have to provide, extra time and training to those employees. You can't discipline them for not being able to use the computer, even though it's a core use of the job. I was subjected to retaliation. We're seeing a lot of people that once they're put on a PIP plan, they tend to start reporting you to protect their job. So we're seeing reports to say OSHA violations because then they believe that that makes them a protected employee and harder to fire. I was not provided an accommodation for a disability. If you haven't heard the term intermittent leave, that is still very much a thing, where basically you can go to a doctor and they say that you suffer from, some disabling stress and the stress comes and goes. So it's almost like employees feel like they can call in that day and tell you whether or not they're capable of working because of this disability and how you navigate complying with the ADA. I was fired due to illness or injury, which is pretty self-explanatory, but you're getting into the Pregnancy Discrimination Act we've had to deal with a couple times this year. And what do you do when people just start taking off for legitimate um, doctor visits? So anyway, those are just some examples that I thought I would share just to show you how prevalent this is. And then if we actually look at some statistics, so this is from the EEOC. So these are actual charges that came out of the EEOC against employers, and it's what percentage of the total charges that were made, what claims were there, just to show you the prevalence. And retaliation is becoming the number one. Whereas if you looked at this maybe 15 years ago, race and sex would be at the top of the list, retaliation would be at the bottom. So now retaliation is number one. Oh, okay, I actually have it over here. So it's 17th year. It's been flip-flopped. Um, disability still up there, race, sex, and age. No real surprise, I think, except for retaliation. Oh, I didn't know we were doing that. It looks like I see some questions. Does the employer have any rights or recourse if someone does not return after taking paid maternity leave? Usually not. That's the short answer. um, because there's a requirement that the employer is holding a job open, but there's no usual requirement that the employee return, unfortunately. Why do employment claims hurt? Because they're expensive and they're often not covered by insurance. So you have to carry a separate insurance policy to cover things like retaliation or sexual harassment complaints or any complaints from your staff. You have to have a separate insurance policy. And in the veterinary space, insurance policies are woefully lacking in this area. Like, um, if you go with cheap insurance, I would say your EPLI policy maxes out at $5,000 to pay an attorney. There's not much I can do for $5,000. Um, the mid-level claim is $25,000. And again, that gets you some protection, but if you have to pay a settlement and legal fees, you're going to be out of pocket a bunch of money there too. And as you can see, those can be significant if there's a real claim. So what's the takeaway here? I mean, it's the same thing. It's train, document, never ignore a complaint. But one thing that I'm going to leave with you is understanding the benefits of attorney-client privilege. So if you're a practice manager and your job is to investigate claims that are made and make determinations on employees, well, if those employees happen to be a highly compensated employee, such as a doctor or an owner, so if, let's just say there's a sexual harassment claim against a doctor or an owner, if you also employ a non-attorney consultant and you happen to call that non-attorney consultant and you made a statement such as, I believe our veterinarian sexually harassed, a vet tech, you should know that that statement is not protected. And when you're sued, the attorney for the plaintiff is going to depose and ultimately find that statement that was made, and it's going to be considered damn near an admission of guilt or liability. Whereas if you have a law firm do the investigation, or you're doing the investigation at the behest of the law firm, it that information will be attorney-client privileged and it's not discoverable. So just keep that in mind. We actually dealt with a client that did their own internal investigation into something very seriously, and all of their records, including text messages between staff members, was subpoenaed. And those text messages between staff members did not bode well for the employer. All right, so I'm going to go through these pretty quickly because I don't know how exciting all these best practices will be to you guys. If you feel like they are, we'll slow down. But if we look at the hiring process, just a reminder to use objective qualifications for the job, be consistent in how you interview, Make sure your application doesn't have anything illegal that you're asking on it. Remove job postings when they're filled. Know what you can and cannot ask during interviews. Train your interviewers. I think that's pretty straightforward stuff. Um, Definitely focus on the concrete components of the job, and you stay away from the protected classes. You can't ask people about their age, their disability, family status, gender, all the way down here to you know, race, religion, sexual orientation. I'll be honest with you, my wife, I had to kick her out of the interview process for a while because she would straight up ask people if they're married. And I'm like, you can't ask people if they're married. You can't ask them if they have kids. I was like, if you want to know if someone's married, look at their hand and shut up. If you want to know if someone has kids, ask them what they do on the weekend because everyone goes hiking or soccer or something with their kids on the weekend. A parent loves nothing more than to tell you how much family time they spend with their kids. So if that's something you want to know, figure out how to ask it without violating the law. Be careful asking for date of birth on an application. There's a proper and improper way to do that as well. Be careful using what we call bona fide occupational qualifications. So that's like you have to have the ability to lift so many pounds. That's pretty prevalent in our industry. Just know that with the invention of lift tables or the ability to squat down in the floor, to say that you have to be able to lift, 80-pound dog is just incorrect. That's not a bona fide occupational qualification to be like a vet tech. Um, you can have two people lift a pet. Like I said, you can use lift tables. You can get in the floor. Like that's not going to cut it. Now, to say you have to be able to lift 35 pounds or you have to be able to hold a dog, I think that's a different story. One that I've had to answer is, can you quote unquote discriminate against people that are allergic to cats? In other words, can you say in order to work here, you can't be allergic to animals? I normally pause and wait for the room to answer this question, but since everyone's mic is muted, um, the short answer is no, you can't do that. That's actually unlawful discrimination because you can control allergies with certain medications, antihistamines, and so it would be unlawful to discriminate against someone who has allergies. Now, they do have to be able to control it. Obviously, they can't go into like anaphylactic shock, things of that nature, but you couldn't just put this on an application and weed people out. This is just some lawsuits that we did. So I represented an employee manager who was fired from a Japanese auto manufacturer during a board meeting because someone made the true statement that our employees, which happened to be in Kentucky, will just not respond to a manager from India. And as a result, they terminated that manager because the employees themselves were racist and basically wouldn't listen to them. And that cost them $250,000. So that was a pretty easy lawsuit that we did many years ago. But I could see that very thing happening in the veterinary industry. It's just you make a blanket statement. The statement isn't false, but it's also discriminatory. All right, just looking at employee handbooks. You definitely want to put one together. It needs to be continually updated. We're constantly updating them on our end. It never ceases to amaze me how employees will squirm around every little clause that we put into a handbook to protect themselves. So we're just going to pull out a couple of the main policies, and some states actually mandate that you have to have certain policies in a handbook. Um, I'm providing this slide to you. This is a table of contents that comes from our generic handbook, just to show you the different levels of policies and procedures that we have in there. One of the most important things from a handbook is the acknowledgement page where the employee signs that they've received it. So you need to be collecting those signatures. And right above that signature on the acknowledgement page needs to clarify that they're employed at will and that this is not creating any type of contractual relationship. It's probably one of the most important things in the handbook, just so they can't claim that the handbook became a contract. It's just some sample language. What else is inside? You have to have a progressive discipline policy. I'm hoping everyone has that, but it is the standard by which law is governed. So if you do fire someone, the for me as an attorney, the purpose of the progressive discipline policy is to protect you against the claim of that's not why I was really fired. It's creating a paper trail to show exactly why the person was fired. So one of the number one phone calls I get is, "Hey, I've got this employee that they're doing A, B, and C. I just want to terminate their employment." And I say, have you written them up before? Like, no. And they say, well, do I have to? I'm like, no, you absolutely don't have to. But failing to write them up or put them on a performance improvement plan or follow your own policy procedure regarding progressive discipline basically makes that a red category on our risk matrix that we talked about or I showed you in the beginning. If you put someone on a progressive discipline policy and then terminate them later, you start reducing that risk that they can sue you by saying, I was actually discriminated against, or this is only happening to me because I made a claim that I was being bullied at work. They come up with some other excuse of why they'd be terminated.
Tony, real quick, we've got a question. Do we need to keep a living document with like a red lines of all the changes that we make, or do you change the dates? How do you keep track of versions of handbooks?
Literally versions. That's exactly what we do. We put in the footer of the document, it'll say like last updated and it has a full date on there. If you put it in the footer, it will also transfer to the acknowledgement page. And then that way, every acknowledgement page would have the timestamp or the date stamp of which version is being signed.
Perfect. And then another one came in. Can it say it's not a contract, or does it need to say employee at will? Are they interchangeable?
It the language should both languages should be there that it's not a
Okay.
contract that you're employed at will.
Okay, perfect. Thank you.
I would say the employment at will is if you're choosing between the two, clarifying they're employed at will is probably the most important. Also, a common misconception. I mean, we have people that call my office and they don't understand that employment at will is like a deferral. Like if you have someone like even like an RVT, if you hire an RVT, they're employed at will in the vast majority of states. If that same person signs a contract, that contract, no matter what it says, supersedes employment at will. Like that's often confused if people don't understand that that's what contracts are for, is to supersede employment at will status.
We're going down rabbit holes now. We've got more questions. Okay, if the
Yeah.
language
Yeah.
is not a contract employed at will, and then sign is in the signed offer letter, does it still need to be in the handbook?
Hmm.
If their employment agreement says it, does it need to be stated twice?
Well, it's not, they're not saying an employment agreement, they're saying just an offer letter. So I assume it'd be a non-contracted employee. You're giving them an offer letter and you're clarifying it's at will. I would say that's sufficient. But next time you update your handbook, you should just modify it,
Thank you.
bootstrap it. Yep. Uh, Policies and procedures manual. So this is just how things get done. It's probably one of the most tedious tasks, but as you get into training, which we're going to talk about in a little bit, um, if you don't have a policy procedure manual, just think about a client that walks in. How do they walk in, receive services? What's all the administrative tasks that need to get done? How do we communicate with that person? Those all need to be recorded, mainly for training purposes, but there's a legal reason too. And if you don't have this, you basically are acting. I would ask your people to do a time study where they just write down what tasks they're doing in a day and they write it down in order, and then you can start building the policy and procedure manual. But it'll really play into training, and that's going to be the best practice here. If you're not using training modules, and I cut the I inadvertently cut out the slide. I wish I could show you, but the training module would set forth all the tasks for a particular duty. So let's just say you're looking at a veterinary assistant, and that training module might have, here is 40 things that every veterinary assistant should strive to be able to do at our hospital. And then it would have a column for the trainer and a column for the trainee, and each one would initial each time that person was competent at doing that task. I cannot tell you how often that saves you in a lawsuit later when you're terminating someone and you say, the reason we're terminating you is because, you can't do A, B, and C. Like your skill set of drawing blood is inadequate. Your skill set for A, B, and C is inadequate. And then the first thing they jump to is they say, well, that's not really my job. I was never told I was supposed to do that. I know I was never told that that was part of my job and I'd have to learn that task. It's real easy for me then to pull up this training manual and see, like, well, obviously you knew it was part of your job because you signed off that it was part of your job. I personally have used this in defending a lawsuit against my own hospital. I once fired an employee who happened to also be pregnant. She was not fired to have anything to do with the fact that she was pregnant. She was fired for basically not being able to hold down a consistent schedule. In other words, she called off just way too many times. Um, Now I didn't fire her because she called off way too many times, because that would could be conceived as, well, you fired her because she had too many medical appointments, for example. I was like, nope. We basically sat back and we waited for her to make a mistake. And one of the mistakes she made is she failed to get a consent for surgery form signed for a patient that was going under surgery. And when we terminated her, she said, no, it's pregnancy discrimination. And I said, no, we fired you. Here's the client. Here's the form. Here's where it wasn't signed. Here's where the doctor caught it. Like, that's the main part of your job. You're fired. That's a fireable offense. And we went all the way in front of a court. And I told the judge very simply, Your Honor, can you imagine if this was a human hospital? Are you saying that if a human hospital operated on a patient without a signed consent for surgery form, that we'd be having the same conversation? And that's when the gavel hit and the case was over. And it was all pointing back to the training manual where we could show that not only were you aware that obtaining a consent for surgery was part of your daily routine, you were responsible for training other people to do the same thing. Here's your trainer initials, so you can't say that you didn't know it's part of your job. Was there another
There
question
is, but it
there?
looks like you're going right into it. So, do policies and procedures, should they live in the handbook or should they be a binder of SOPs on their own?
Yeah. The actual like how to do what, I think I would pull it into a separate SOP manual. I wouldn't put it in your handbook. There are some policies though, but they're mainly like overview policies, like a sexual harassment policy. That has to be in your handbook. I mean, it has to be. Um, but like how to do something can be in a separate SOP manual, and that's the way my hospital does it too. So this is just a step-by-step guide. If you're setting new policies and procedures, it's pretty generic, but the first thing is to perform an audit and risk assessment. That's something that we used to do. We used to do a 101 point risk assessment using that matrix that we showed you in the beginning, just to see like where a hospital's at, what their forms and consents look like, and then we work backwards to implement new policies, procedures. Best practice, don't retaliate against whistleblowers. So that's becoming one of the biggest claims right now, is that basically someone complains a lot, but if they complain a lot about something that statutorily is protected, you can't terminate them for that. Uh, it's been popular ever since COVID. there were a lot of, I had a lot of COVID complaints where you would have employees that were scared at the time. Some would say overly scared, but maybe, in 2020, 2021, I don't know if you could adequately say they were overly scared, but they would say, my employer is not making us wear masks. Our employer is not making us social distance. Our employer is not doing A, B, and C. And the employer says, I'm sick of it. This person is basically causing a mutiny, wanting us to all wear masks, and then I want to fire them. Like, well, that became an OSHA retaliation complaint pretty quickly. So make sure that there's a legitimate reason for any adverse action. You back that up by your performance improvement plan and your progressive discipline policy. Be able to prove the legitimate reasoning. And the last one that no one follows is be able to prove that others were treated the same way. So we used to laugh at my hospital, or at least internally, we would laugh that everyone got written up for everything. And the reason I did that is because we tend to write up only bad employees. And if you've had an employee who's been with you for 5 or 10 years, you kind of let their one or two mistakes slide by. The problem with that is it delegitimizes when you actually write up someone that you want to get rid of, because they'll claim that you're singling them out, that that's not a rule that the hospital actually follows on a daily basis. So you're going to have to be consistent and even write up those good employees when they make a mistake. You write them up, pull them into your office, shake their hand, say, "Hey, I know this never happens. This is just a mere formality. Thank you, goodbye," and you throw it in their file. I'm a big proponent of not letting one bad apple spoil the rest. I do fire and counsel people in firing a lot of people. I don't mess around. I don't mess around with my staff. Um, I tend to be very light on performance improvement plans, and we follow the 3A policy at all of my businesses. So the 3A's are, what do you look for when you're hiring someone? I hire people based upon attitude, number one. Do I want to come in and work with this person day in, day out? I don't care what their skill set is yet, but it's just based solely on attitude. So when you come to interview, I'm hiring you based upon attitude. Uh, Within 30 days, I expect you to show me some aptitude, that you have the ability to learn what I want you to learn. If you don't show aptitude within 30 days, I just go ahead and cut it then. I'm not going to try any longer, because people tend not to try harder 6 months from now than they're going to try in the first 30 days. And then in the first 90 days, that's when we look for ability. Are you showing actual improvement in your ability to do the job? If you're not showing that you have the right attitude, aptitude, and ability in 90 days, I just let you go. You're dead weight. You're slowing everyone else down. And that's just the way we do it. Sorry, I'm reading and reading silently. So there's a question here going back to the personal story regarding terminating the pregnant employee. Was the employee terminated following that offense, or were there several occurrences prior to that? So we chose for that particular employee to not write her up for all of the absences. And that was an internal legal decision of half of her absences had to do with morning sickness, half of the absences would have to be do with, surprise doctor visits, or at least that's what we were told, right? We're like, I'm not sending someone around to follow her to see why she's really not coming to work. But what I'm looking at as the employer is, the truth of it is you're missing, say, 25% of your shifts. You're either tardy or you're absent. I don't really care why. I don't care. I have a business to run. I need someone that can show up on a regular schedule basis. Like, I'm not permitting you to have intermittent leave where you just come in. You work whenever you want to work. You don't have to allow intermittent leave. So to answer your question, we had not put her on any type of performance improvement plan. I made the argument that failure to obtain a surgical consent was an immediately terminable offense, that it's a heinous error. that someone that had worked for us for a couple years definitely knew better. Uh, in the world of law, as far as at will employment, you're allowed to fire people because they don't like the cut of your jib. That's just a legal term. Basically, you can fire people just because you don't like them. And this whole concept of don't discriminate against people is actually not correct at all. As an employer, you absolutely discriminate against people. When you're looking through 30 resumes, you are by definition discriminating against the different people to determine who you want to hire. The answer is you can only discriminate for legal reasons. There's just a list of reasons of which you cannot discriminate, and they tend to fall here. So race, color, religion, sex, national origin, pregnancy, familiar status, don't violate the Fair Labor Standards Act, FMLA, ADA, which is age discrimination, Americans with Disability Act. So there's a whole list of reasons why you can't discriminate. But if if you don't like that someone has facial piercings, you're allowed to discriminate against that. If you don't, I don't like someone because they're a smoker. If someone comes into an interview and smells like cigarette smoke, I won't hire you. I'm allowed to. I don't want to. Um, do you transparently share those aptitude and ability milestones with new employees? Yes, 100%. I do. All right. Last one here, I think, is best practice avoid defamation suits. Don't give bad references. I encourage you all to only answer 3 questions when you're giving references on anyone, even if they were the best employee who ever lived. Only answer 3 questions. If whoever you're talking to on the phone cannot understand what you're trying to tell them by answering these 3 questions, then they are an idiot and they should stop asking you questions. So you can answer the dates of employment, the position held, and whether or not they're eligible to be employed there again. If you tell someone else that they're not eligible to come back and be employed by you, they should get the hint. They don't need to know why, and you definitely don't need to say why. Um, we did a lawsuit once here in Kentucky. It's actually well, we weren't part of the lawsuit, but it's a famous case that an attorney was passed over for a job because I don't remember. He liked University of Kentucky basketball over, Louisville basketball. Right? It sounds completely stupid, but he was trying to get hired by like a Louisville firm, and the Louisville firm said, "Well, we don't want Kentucky back. Our culture here is built around, Kentucky basketball." So, can you discriminate based upon that? Absolutely, you can. We only hire, fans of one ball club. You can do that. But that information came from a former employer. And so that attorney claimed that that statement was untrue and defamatory and cost him from getting the job. And that was a lawsuit that enveloped there. So be careful what you say, even when it's good. All right. I'm trying to get off of that last topic because it looks like we're, we're running about 20 minutes. Is that right, Megan? About 20 more minutes? All
Yes.
right, I think I can get there then. All right, so that's leaving employment law and discrimination cases, and so these are going to go a little faster now. Those tend to be the main reasons people call, but there is a movement right now in the veterinary space where there's a lot more board complaints against doctors, and there's a lot more malpractice lawsuits against hospitals and doctors. It is a trend. It is not going to go away. It is going to keep getting worse, especially the way veterinary boards are reviewing these. And if I were to boil down the number one claim, it ultimately comes down to having improper or insufficient informed consent and recordation of declined services. So if you're going to have a proper informed consent, you're going to have to hit these 5 key categories here. So you're going to have a diagnosis or condition, have a recommended treatment plan, and then you have to talk about the material risk of proceeding, the material risk of declining, and what those potential alternatives would be. and an owner's signature. And you're going to find out over the next 5 years that, verbal consent is basically worth the paper it's printed on. It's not working. And I'll give you a personal story about that in just a minute. The minimum is not enough. I bet if half of you go and you look at your informed consent, it's going to say something like this: that I've been advised the nature of the procedure mentioned above and the risk involved, and I realize that results cannot be guaranteed, and I release the doctors of Google Veterinary Clinic from all liability regarding surgery. If that's what your informed consent looks like, you better look into getting it changed, because it is being consistently shot down by veterinary boards as insufficient. So that particular one, the waiver is silent on the risk discussed. You can't just say that I've discussed all risk and asked all questions. That's not what it is. Those risks have to be in the document. You have to talk about the possible complications. Is there suture removals? Is there potential goggle recovery? Length of time for activity restraint? Um, One way to get all of this is to attach go home instructions for potential surgery. You attach it to your informed consent/consent for surgery form. Basically, give go home instructions at that time. And if you go back to that release I just gave you, this one is fatal. It actually says that you hereby forever release and discharge the doctors of the hospital. Um, It only releases the doctors. It doesn't release the hospital or the rest of the staff. So that's actually terrible. It's actually completely incomplete. So, in addition to the risk, what should be an informed consent would be the reasonable medical and/or surgical treatment options, sufficient details of the procedure, what will be performed, how your pet will recover, how long it will take, common and serious complications, length and type of follow-up care and restraint required, and the estimate of fees and payment arrangements. Looks like we have a question here. Some owners just like to X for additional treatment things, but will sign at the bottom. Is that sufficient, or do you recommend an initial and sign? I don't. In the world of law, I mean, whether someone puts an X or an initial literally has no bearing. They don't even have to actually initial unless they're like making a choice in like a checkbox. Them initialing next to a bullet point means nothing in the world of law. I mean, sure, I guess it's better acknowledgement that they read that very specific paragraph, but if they sign the bottom, it doesn't really matter. Signing the bottom is anything above your signature would be protected by the signature at the bottom. Okay, so I just did this case. That's kind of why it's a hot button topic for me. I had a hospital, just a regular GP practice that doesn't do overnight care. They had a patient that needed overnight care and monitoring, and they gave options. This was just after COVID, but anyway, they gave the client some options. Go to a 24-hour facility. Uh, just so you know, we're not here overnight, and or you could take the pet home. And the client said, "No, I don't want to take the pet home. I don't think that I'm capable of caring for them. I may get called out in the middle of the night to go to work, and I don't want to pay the money to send the pet to 24-hour care." So they left the pet there. Um, Pet died overnight. They filed a board complaint the next day saying that it was improper. Um, the client did acknowledge to the veterinary board that they were told that the hospital was not open 24 hours, but they followed up by saying that they didn't really understand the full breadth of the decision they were making, and nothing was signed. The veterinary board said that a blanket acknowledgement that you're not open 24 hours is insufficient, and that they charged this person, put them on probation, made them do CE, and pay a fine. So, based on what I learned from that discussion, what would have to be in such a waiver? And again, don't use this because this is not the full document. This is just the main items that would need to be in there. So you're advising someone they require 24-hour care, overnight monitoring, and you'd have to say, what the reasoning for that is. So someone's going to have to type in the reasoning. Doctors recommended referral to a 24-hour facility. Our hospital does not provide and reopens at certain time. I understand that leaving it here could cause deterioration, health complications, and or death. So that's the alternative. And then the risk of not following our advice. I've declined 24-hour care. I'd like to leave it here. I accept responsibility and release and hold harmless the hospital and its doctors and staff. And then I was offered referral care. I declined to keep my pet at home. That's probably about the best that hospital could have done to protect that doctor. Just a list of typical hospital vet forms that should be routinely used. So AMAs, consent for surgery and anesthesia, consent for drop off, dental consents, euthanasia aftercare, medical records release, restraint by owner, which is not used enough, in my opinion. By the way, we have a case right now in Florida where an owner's nose was bit off by their own dog because they were too close uh, while the dog was being poked and prodded, and the staff member didn't hold the dog. So not being vigilant about separating the owner from their pet is going to cost that hospital a boatload of money. Um, Waivers for declined services, also not heavily used, and we keep going from there. So question, so this should be a part of all hospitalization forms if we suspect they will be staying overnight. Yeah, I mean, it's probably going to be hospital dependent on whether or not you want to build this into a hospitalization form. But yes, I would say if you're not a 24-hour hospital, you're routinely doing hospitalization, then yes, I would probably build that in and make sure that they have a very specific informed consent waiver that they're choosing your hospital. And you're going to have to specifically tell them the time that you leave. And according to at least the Kentucky Veterinary Board, you would have to also inform them the last time that someone is or is not going to come by and check on that hospital, and the vet or check into the hospital. The vet board in Kentucky slammed this practice, saying that doctor should have came back at least once, at night after they closed to check on that pet. So take that for what it's worth. Reminder that less than 10% of people read contracts. So when you draft them, you draft them for the 90% that don't read them, not the 10% that do. So if it's a very dense contract, just remember no one's reading it. It's there to protect you. Failure to read a contract is known as a unilateral mistake, which means if the kitten sells his soul to the devil, didn't read what it said, doesn't matter. It's not a defense. Oral agreements are worthless. I'm going to skip through some of these just so we can get to some other topics. Um, Dog bites and injuries. So dog bite are up. You can see that the average payout for a dog bite is up 18.9% in 1 year. So they're just getting more and more expensive and prevalent. Sorry, there's a question that says, do AI scribe recordings help in court if needed? I guess it would depend. I don't know. I mean, obviously that hasn't happened yet. So having a recording with a client could help. It would help a lot better though if you had the raw data recording of actually what was said rather than an AI scribe of that recording, unless it was verbatim. Um, it would be introduced as evidence and part of the medical record, but it's not going to be valid as a signature. So it's not going to absolve you from a claim the client's informed consent and signature. And it could actually backfire. just in a lot of respects, it's easier to get a signature on a piece of paper than it is to get the client to say the key magic words that would convince a court or a vet board that they were fully informed.
Just real quick, we skipped one. Is it sufficient for a tech or assistant to check on the pet that stays overnight? Or does it need to be a doctor?
Hmm. No, I think it would be sufficient because then the claim would be that that tech or assistant could at least, notify the on-call doctor, assuming you had someone on call, but could notify someone. I think that'd be all right. Dog bite statutes. Just know that dog bite statutes typically cover veterinary hospitals because they're known as harborers of dogs because you have dogs on your premises routinely. So, under a statutory definition in most states, a veterinary hospital is the legal owner of a pet, even though they're not the actual owner of a pet. The reason that's bad is if that pet bites someone when it's in your custody, you're responsible for it. There is no ifs, ands, or buts about it. It's covered by a dog bite statute. So that leads me to a couple of best practices here. When you take the leash, you take control of the patient, period. Don't deviate unless you get a waiver signed from a client. So we used to train my staff downstairs on like how to step in between. Like if you're an assistant and you're holding a pet, how to step in between the head of that dog and move that dog's head and get the owner out of the the owner's face out of the front of their dog. And if the owner is insistent on being part of that interaction, we bust out a waiver, sign it. When the dog bites you in the face, just know that we tried to protect you. Um, and the newest argument that I'm making is that practices should start keeping FAS scores on every patient. I think in the next 5 years, that's going to be the standard of care that you're going to have to start making notifications as to the fear, anxiety, and stress score of a patient rather than just saying patient needs muzzled. Um, if you know, once you discover that a patient is dangerous to your staff or people that would be in the practice, you're going to have a duty to protect your staff and your patients from that. And that becomes a legal duty as soon as you know it. So you're going to have to start recording it and taking steps to protect your staff and the patients whenever a high FAS scored patient comes in. Uh, that's a pet project of mine. I actually launched my career doing a lawsuit on behalf of a kennel owner. That kennel owner went through three attorneys, and all three attorneys told her that she assumed the risk of getting bit by a patient. And I said that that is true under the dog bite statute, but that is not true under what we call a duty to warn tort. So anyone who knows that their dog is dangerous, including a client that just brings a patient into a hospital, if that client already knows that their dog is dangerous, they have a duty to warn anyone who comes in contact with that dog. And that would include a veterinarian. Specifically, it would include a veterinarian. And so if they don't muzzle their dog or make their dog behave, then they're liable for that. So um, this particular kennel employee got bitten by this dog. Um, we researched it thoroughly, found out the dog was dangerous. It had previously bitten three people. It was kicked out of another kennel, and the client in or the patient intake form asked the question, is there any known behaviors of this dog we should be aware of? And that client wrote on there, the dog loves long walks and women, which I enjoyed telling to the court and the jury quite often. That he loves long walks and women, and he this client had 80 something puncture wounds in her hand and arm, broke her hand, broke her wrist, broke her fifth metacarpal, and she had to have two reconstruction surgeries on her hand. So um, anyway, dangerous dogs you got to take care of. DEA violations. Uh, these are pretty standard, but they're coming up uh, more often of not doing a regular inventory reconciliation. The one that I'm seeing, I saw a client get in trouble for this in Florida. is allowing unlawful substances on the premises. And this is becoming a problem because of legal cannabis products. So just remember that marijuana is still federally illegal as of today. And as far as I know, all doctors that are in hospitals have DEA licenses, which is a federal license. So you have to be mindful that although a state law may permit marijuana on the premises, that is still illegal federally, and why they have been certain lackluster about enforcing it. They are starting to draw the line somewhere. So this particular hospital was dealing with an employee who quit. They opened her locker and they found unmarked bottles of drugs in there. They didn't know what it was. So you report it to the DEA. The DEA says you should have done a better job keeping these illicit drugs off the premises. Okay, my favorite, misclassification of employees. So this is the one that like almost everyone fails, right? You start hiring relief vets. The relief vet demands to be hired as an independent contractor, but the IRS used to have a 20-factor test to determine whether or not someone is truly an independent contractor or a W-2 employee. They have now went back to this 6-factor economic realities test, where they just pulled out the 6 main factors from the original 20. And how these factors play out determines whether or not someone was misclassified. And then you owe a bunch of penalties, fees, and you're subject to all of the ADA, FLSA, and all the other employment requirements that would have been there had they been properly classified as a W-2. So just keep in mind the number one is the opportunity for profit or loss based upon their managerial skill. So if you have a relief vet and they're paid hourly or a flat fee per day, that strongly favors the fact that they are a W-2 employee. If you're paying them production for the day, that might actually switch the other way. Uh, Investments by the worker versus the practice. If the relief vet is coming in, they're using all of the practice's drugs and software and everything else, that strongly favors that they're a W-2. If the relationship is, the more permanent it looks, and the example given here is this vet works for us every Monday or Tuesday of every month, man, that's almost a dead ringer for an employee in most states now. Nature and degree of control. The practice sets the hours of operations. They set the fees, the medical records. Again, W-2. Is the work integral to the business? Unless they're there doing a service that you do not do in hospital, that strongly favors them to be a W-2. So like a traveling surgeon that comes in to do like orthopedics, great. That person can be classified as a 1099. But if you're a GP practice and you've got GP relief vets coming in and they're there on a regular basis, you could be damn sure they should have been a W-2, at least in most states, vast majority of states. Disease number 6 is OSHA violations. So again, OSHA has been coming back around. Their newest one is actually new to me. I've been trying to contact them about this one, but they want they want every practice to have a bloodborne pathogens exposure control plan, which is kind of, to me, it's a little silly because I don't think that animal bloodborne pathogens have anything to do with human medicine. Um, but they don't care, is the response that I've gotten so far. Um, so you got to add that to your list of OSHA compliance, and then the rest are pretty self-explanatory. My personal favorite is feeding the trolls. So as you navigate social media reviews, uh, just a reminder, if you call my office, this is what I'm going to tell you. They're normally short-lived. If you do respond, just remember that the response is to the reader of your response, not to the troll that made the claim. You're not responding directly to them. You're trying to respond to the other people that are reading. Uh, Report it to Google or Facebook. Try to get it removed. They often have anti-bullying policies, or you can argue that it's defamation. You can send a short cease and desist letter, but just keep in mind that that often feeds the troll. They'll take my letter and then they'll post it online because they don't care. And they basically force you to go file a lawsuit if something is defamatory. So the worst thing you can do is go get into an argument though online. And the one that I've dealt with just this morning is keeping bad clients. So I think that we should take a better look at getting bad clients out of the hospital. Just realize that you're not completely open to the public to where you have to treat everyone. If someone is verbally abusive, or in the case I dealt with this morning, uh, I'll give you a little bit of a background. There's an older gentleman who comes in quite regularly. Um, he has trouble hearing, and so he often communicates with his cell phone by typing out messages to hand back and forth to the staff. That's not uncommon. He typed out a very lewd and highly inappropriate sexual message to the staff member and then handed the phone to her and made her very, very uncomfortable. And now we have to figure out what to do with it. Well, that's a pretty easy call, right? That you just terminate them. But just remember that if that patient is in the middle of treatment, there are other things of which you have to consider rather than just terminating them on the spot. So definitely get rid of the bad clients. I have found through my own hospital that your staff will appreciate you. It actually really increases morale to get those people out of there. Boom, Megan, what do you think about that? I got it in an hour.
You did. Man, that was a lot. I don't know if I feel better informed, more afraid, all of the above. I think we had some great questions. You had awesome answers. I do want to wrap up. If you guys need CE for today, please email us at events@granitepeakcpa.com. We're doing, keeping it going. January 9th will be our next one. I think we're doing HR, so that'll be fun. We're just keeping it going. It was great to see everybody here today. Anthony, thank you so, so much. This was fantastic. It'll be up on the YouTube channel later on this afternoon, and I hope you guys all have an amazing holiday and a happy new year. Thank you.